this episode, we will be discussing Arizona Tenant Abandonment of Property. The Arizona Residential Landlord and Tenant Act allows landlords to take the following action when tenants abandon the rental property and leave behind personal belongings. Definition: abandonment under this section means either of the following: an absence of the tenant from the dwelling unit without notice to the landlord for at least 7 days. Rent is outstanding and unpaid for 10 days, and there is no reasonable evidence other than the presence of the tenant's personal property that the tenant is occupying the residence or the absence of the tenant for at least 5 days. Rent is outstanding and unpaid for 5 days, and none of the tenant's personal property is in the dwelling unit. Notice of abandonment. If a dwelling unit is abandoned after the time prescribed in this section, the landlord shall send the tenant a notice of abandonment by certified mail, return receipt requested, addressed to the tenant's last known address, and to any of the tenant's alternate addresses known to the landlord. The landlord shall also post a notice of abandonment on the door to the dwelling unit or any other conspicuous place on the property for 5 days. Taking possession of the dwelling unit. 5 days after the notice of abandonment has been both posted and mailed, the landlord may retake the dwelling unit and re-rent it at a fair rental value if no personal property remains in the dwelling unit. After the landlord retakes the dwelling unit, money held by the landlord as a security deposit is forfeited and shall be applied to any accrued rent and other reasonable costs incurred by the landlord by reason of the tenant's abandonment. Renting out the dwelling unit. If the tenant abandons the dwelling unit, the landlord shall make reasonable efforts to rent the dwelling unit at a fair rental. If the landlord rents the dwelling unit for a term beginning before the expiration of the rental agreement, the rental agreement is deemed to be terminated as of the date the new tenancy begins. If the landlord fails to use reasonable efforts to rent the dwelling unit at a fair rental, or if the landlord accepts the abandonment as a surrender, the rental agreement is deemed to be terminated by the landlord as of the date the landlord has notice of the abandonment. If the tenancy is from month to month or week to week, the term of the rental agreement for this purpose shall be deemed to be a month or a week, as the case may be. Storage and disposal of personal property. After the landlord retakes possession of the dwelling unit, and if the tenant's personal property remains in the dwelling unit, the landlord shall prepare an inventory and notify the tenant of the location and cost of storage of the personal property in the same manner prescribed in the subsection Notice of Abandonment. After the landlord retakes possession of the dwelling unit, the landlord may store the tenant's personal possessions in the unoccupied dwelling unit that was abandoned by the tenant, any other available unit, or any storage space owned by the landlord, or off the premises if a dwelling unit or storage space is not available. The landlord is not required to store the tenant's perishable items, plants, and animals on behalf of the tenant. The landlord may remove or dispose of, as appropriate, the perishable items, including plants. At the landlord's discretion, the landlord may also remove and dispose of any personal property in the dwelling unit that is contaminated or may be considered a biohazard or poses a health and safety risk. Abandoned animals. At the landlord's discretion, the tenant's abandoned animals may be immediately removed and released to a shelter or boarding facility. If so, the landlord shall keep a record of the name and location where the animal was released. If the landlord does not immediately remove and release the abandoned animals, the landlord shall provide reasonable care for the animals for the period prescribed by the next subsection 14-day hold required. If the landlord is unable or unwilling to provide reasonable care to the animals, the landlord shall notify the county enforcement agent as defined in Section 11-1001 or an animal control officer as prescribed in Section 9-499.04 of the presence of the tenant's abandoned animals on the property to be seized pursuant to Section 13-4281. 14-day hold required. The landlord shall hold the tenant's personal property for a period of 14 calendar days after retaking possession of the dwelling unit. The landlord shall use reasonable care in moving and holding the tenant's personal property. If the landlord holds the property for this period and the tenant makes no reasonable effort to recover it, the landlord may donate the personal property to a qualifying charitable organization or sell the property. Selling the tenant's personal property. If the landlord sells the property, the landlord shall retain the proceeds and apply them toward the tenant's outstanding rent or other costs that are covered in the lease agreement or otherwise provided for in this Act or Title 12, Chapter 8, and that have been incurred by the landlord. And excess proceeds shall then be mailed to the tenant at the tenant's last known address. A tenant does not have any right of access to that property until the actual removal and storage costs have been paid in full, except that the tenant may obtain clothing and the tools, apparatus, and books of a trade or profession, and any identification or financial documents, including all those related to the tenant's immigration status, employment status, public assistance, or medical care. The landlord may destroy or otherwise dispose of some or all of the property if the landlord reasonably determines that the value of the property is so low that the cost of moving, storage, and conducting a public sale exceeds the amount that would be realized from the sale. Any tax benefit associated with the donation of the personal property belongs to the tenant. 12 months record keeping required. For a period of 12 months after the sale, the landlord shall keep adequate records of the outstanding and unpaid rent and the sale of the tenant's personal property. Hold for the benefit of the tenant any excess proceeds that have been returned as undeliverable. Tenant's intention to remove personal property. If the tenant notifies the landlord in writing, on or before the date the landlord sells or otherwise disposes of the personal property, that the tenant intends to remove the personal property from the dwelling unit or the place of safekeeping, the tenant has 5 days to reclaim the personal property. To reclaim the personal property, the tenant must only pay for the costs associated with removal and storage for the period the tenant's personal property was stored. If the landlord fails to surrender possession of the personal property to the tenant upon receiving payment, the tenant may recover the possessions or an amount equal to the damages determined by the court if the landlord has destroyed or disposed of the possessions before the 14 days specified in this section or after the tenant's offer to pay. Immediate disposal. If the tenant returns to the landlord the keys to the dwelling unit and there is personal property remaining in the dwelling unit, the landlord may immediately remove and dispose of the personal property without liability to the tenant or a third party, unless the landlord and tenant have agreed in writing to some other treatment of the property. For additional laws and articles, visit AmericanLandlord.com.